good faith in utilizing the dispute mechanisms provided by the agreement's disregard for mediation efforts by various stakeholders in violation of a court order from the Industrial Court stopping the ongoing strike as grounds for its withdrawal. Now, this even as the two parties are currently appearing before Employment and Labor Relations Court at Milimani this morning. Now, let's cross over and listen in.
This will serve together with the application and the order.
Okay.
Subsequently, Your Ladyship, and despite the order, indeed the full knowledge that the court had issued an injunction staying the notice of industrial action, and further in the full knowledge that the industrial action, which had been threatened in the notice to which we refer, constituted an unprotected strike, beginning on the 4th of November, the respondent and its members proceeded on strike, withheld their labor, and effectively grounded the operations of the applicant. That strike continues unabated to date, Your Ladyship. And for that reason, by an application dated the 6th of November, and which was placed before you yesterday, 7th of November, we commenced contempt of court proceedings on behalf of the applicant. Your Ladyship, being satisfied with the urgency of the matter, issued an order requiring (11) named individuals to appear in court before you this morning to show cause why they should not be punished for contempt of court. And so this morning, Your Ladyship, we are before you for the purpose of those named individuals who are the officials of the respondent to show cause why they should not be punished for contempt of court.
That's all.
Your Ladyship, I see that they have turned out in full force this morning. And perhaps it is appropriate for the named individuals to identify themselves because they are the ones required to show cause.
Yes, you're not finished.
Yes. Let me add, lastly, Your Ladyship, that the order requiring the contemners to appear this morning and show cause why they should not be punished for contempt of court was served in the same way as the order of injunction, which was issued on 31st October 2022. That's all for now.
Thank you. Mr. Who wants to address the court now? Mr. Kimani?
In the first instance, we came on record yesterday. We were instructed in the afternoon.
Let's see the. We have on record Kimani Kiari.
Yes.
So all the three of you are from Kimani Kiari.
Yes.
Okay.
And when they did the order that senior counsel was cited was served at 4:40 p.m. in the evening. And whenever we have made effort to...
You will go slowly. It was served at
4:40 p.m. But at that time, both the parties were involved in discussions. But we have made efforts to round up and bring the named members in deference to the court. But concerning the order, we have two preliminary points that we want to raise. Before the court can give directions on the hearing of the subject.
concerning the order of yesterday.
Yes, concerning that one. We have got limited, we have to also want to raise.
You have two POs.
Yes, and I'll ask my colleague Mr. Karaoke to address you on that specific. Those two preliminary points from that procedure.
Yes, Mr. Karaoke.
If it may please you, my lady, as introduced by my young senior, my name is Levi Munyeri.
Levi?
Levi Munyeri.
Not Karaoke?
Levi Karaoke Munyeri.
Okay. So we go by Karaoke or Munyeri?
My lady can use both names.
Okay. Mm-hmm.
My lady, I stand on a preliminary issue, 2 in number. My lady, the second one is dependent on the outcome of the first one. And I'm therefore obliged to argue the first application first. My lady, I bring to the attention of the court of the defectiveness and error on the face of the court record, being the court orders dated 7th November 2022, my lady, the orders are in pursuit of the petitioner's application for contempt that is dated the 6th of November 2022. My lady, the orders seek to hold the officials of the respondent in contempt of this court for failure to comply with the court orders of 31st October 2022. My lady, the application...
Just a minute. Yes.
The application was served by the official email of the respondent at 4:40 p.m. yesterday, the 7th of November 2022, while actually the officials were embroiled in negotiations towards an amicable settlement of this labor dispute at the NSSF building in the Ministry of Labor. My lady, content of court orders are very specific. The rules and regulations by the court in terms of jurisprudential trajectory are well settled. My lady, by the admission of my senior colleague, these orders were not served specifically to the individual pilot officials that are being sought for content of this court. My lady, specific service to specific individuals cited for contempt of court is of critical nature to such proceedings. And my lady, the error to do that is manifest before you today. My lady, one of the persons cited, Madam Christine, my lady, I'm for her, besides Madam Christine Kabioki, is actually an office administrator in the office of the respondent, performing purely administrative roles, and hence is incapable of enforcing a court order that requires the indulgence of elected officials. And to that end, my lady, among the list that is before you today, and for want of individual service, a wrong person has been cited for contempt. My lady, that matter being preliminary, I return to the limb of my application of effectiveness on the face of the orders of the 7th of November 2022. My lady, the application that was filed before you seeks 3 substantial orders, 4 in number, my lady, The first one is that the matter be certified as urgent. The court proceeded with that. The second order that the petitioner is seeking, my lady, is substantive in nature, in the sense that, my lady, for it to be granted the natural right to be had that is bestowed on the intended persons should actually be granted. My lady, we submit before this court that it was in line with the rights to natural justice and the right to be heard under the Constitution, Article 50, my lady, that the above named officials ought to have been granted a chance to file substantive replies to this notice of motion application through their respective counsel before the court can proceed and issue an order number 3, which actually is to the point that they are already in contempt of this court. And they actually come in here to show cause why they should not be punished. Consequently, my lady, save for the possibility that it could be an error in the extraction of these orders by the petitioner, the orders essentially are in error on the face of each, my lady, for seeking that the respondent officials actually serve with the orders, my lady, presumably, so that they can enter appearance, appoint advocates of their choices. My lady, in such sui generis proceedings, every member that is cited for contempt has a right to seek specific representation. And my lady, the court proceeding and holding them in contempt is tantamount to a gross denial of their natural right to be heard. And my lady, for that error, on the face of the orders dated 7th November 2022, which we believe might be inadvertent or an error in extraction of the same, my lady, we prayed before this court this morning that the individual officials of the respondent are granted sufficient time to appoint advocates of their choices for purposes of opposing the application to hold them in contempt. My lady, specifically for official number 11, she should get an opportunity to bring before this court the requisite documents indicating that she is an administrator in the office of the respondent and therefore incapable.
All right, that is KQ and KALPA in court trying to present both their cases, and the court is expected to give the way forward even as we wait for the final verdict. All right, now my colleague Brenda Zeda-Radido is joining me in studio, and she's going to be continuing with News Center, and we are going also to be following up on this story even as we continue. That's it for Business Cafe. Brenda Zeda-Radido, welcome.
Thank you so much, Kelvin Nyakundi, for that. Of course, we continue bringing you up to date with what is making the headlines, including the vetting of Japheth Koome, who was nominated to the position of Inspector General of Police. He's currently is currently facing the National Assembly and the Senate Assembly security committees when it comes to that position. And we'll be giving you that live coverage later on. But for now, I'd like us to cross over back to the Labour Court in Milimani, Law Court, where KQ and the Kenya Airlines Pilots Association, the members, officials of KALPA, are in court when it comes to the contempt of court for not obeying the court order to suspend the strike until the case is heard and determined. So far, what we know, it is that KALPA is saying that the 8 officials of KALPA were not served with that court order. Hence, the court should not take any action against them as requested by KQ through their legal team that is currently in court. So we cross over back to the Labour Court, sorry for that, and listening live.
That accumulated to the orders of the 31st of October 2022. We have to implement it.
We will be having another application, but I believe it is right for my colleague to respond to. But we will be having another application.
Okay.
Yes, everything they have to say.
Yeah, then can respond together.
It is not in doubt that.
So that is Mr. Kerry now.
It is not in doubt in our minds that everybody in this courtroom that the nature of the dispute is one that is critical to the nation, to the economy, and to all sectors of society. And the respondents, my lady, are also very much aware that the withdrawal of their labor has far-reaching effects. My lady, for that matter, since the industrial action commenced on Saturday, there has been many meetings that have been held between the respondents and even the practitioner. The very first meeting was moderated by the Central Organization of Trade Unions, that is KOTU. That was the first meeting that was held between the two parties to try and come to an understanding. My lady, there has been a meeting chaired by the Permanent Secretary, the Authority Confederation, the Ministry of Labour. There has been a meeting held between the parties by the Permanent Secretary, by the Cabinet Secretary himself, the Ministry of Transport. There has been a meeting as late as last night. In fact, the meeting ended past midnight, chaired by the Commissioner of Labour in the Ministry of Labour. But then there have been overtures from various players in the industrial sector, the Federation of Kenya Employers, and many other players. As we are in court this morning, the parties have been required to attend a meeting at Parliament. This morning the meeting was slated for 10 before the department, before the committee on transport and related matters. So that even as we argue the legal points concerning this dispute, a lot of ground has been covered by the parties. My lady, I can confirm to you that the respondent has drafted and circulated its own proposal on a formula to return to work. That proposal has been received by the petitioner, the airline. My lady, the airline has responded to those proposals, and from our review of the same, respect to appointment last night, my lady, in broad strokes, I could say it covers almost 70% of the issues in this.
Just a minute.
Yes.
I want to hear that well. You're saying your client has done proposals to the airline?
Yes.
And you feel the airline has not responded?
No, they have responded. They have given the counter proposals, and that have been reviewed by the respondents. And I am saying from our own review that almost 70% of the issues are fairly agreed upon. So that my lady, these court orders, the summons, were served right at the point where the parties had reached quite a good momentum as of yesterday to be able to reach an amicable settlement. Now, in that background, therefore, it is our instructions to apply before the court that what has been missing is a structured discussion between the parties in terms of the framework provided by the law. By having formal mediation in the matter, and therefore our application this morning is that the court very kindly does direct that this matter proceeds for court-arrest mediation,